Welcome back to part three of our training module for EUOs and no-show statements. Section three, we'll be talking about verification requests and delaying claims using verification requests in our various forms. Last we left off, Christina, you were actually right on that topic. So take it
Yep.
away.
It's okay. So right now we're in the process of verifying these claims, but we're also thinking in the back of our head that plaintiffs and applicants are always looking for a way to get out of the obligation to respond to those verification requests. Oftentimes they're looking to get out on a technicality.
Of
And so
course.
what we have discovered through the course of dealing with many judges and many different venues and courthouses and arbitration is that a common argument that we see from the other side is that what we are issuing are not actually verification requests. We're not actually requesting something, but rather just apprising the other side of some type of delay. In other words, we're sending out these letters, we're calling them verification requests, but really, in essence, what we're just saying to them is, hey, your claim is pending something else happening, pending a signed statement, pending an EUO. And oftentimes, judges and arbitrators do not favor us doing that. And so, our suggestion is in order to make sure that these are actually verification requests, we're actually requesting something specific, something tangible. Our suggestion is to check off the box of asking for photographs. We have seen time and time again that once that box is checked and the verification requests are now saying, well, we do have a signed statement coming up, or we do have an EUO scheduled for this date. And also, we are asking for verification of photos, for example. The judges automatically now consider these just what they are, verification
That's a
requests.
completely legitimate, reasonable thing that probably on all of these cases where we're asking for a signed statement, to ask for photos, to ask for any video footage, this is all relevant information. We don't know it exists until we ask for it. So that those
Right, and because
should
we're
request.
wind up we wind up asking for these documents anyway during the course of our investigation, during the course of our EUO when we conduct them. So whether we request them at the time of the EUO or prior to the EUO, at least we're preserving our right to call these verification requests. Otherwise, sometimes we've seen plaintiffs argue that they're merely delay letters, and sometimes, unfortunately, the judges and arbitrators go the way of the plaintiff.
Well,
I think Christina, you just said you went on a
yeah,
motion
they
to
actually win a
similar.
lot.
It was at 11 o'clock this morning, in fact. And we were arguing EO no show. And one of the things that plaintiff raised was, well, they're insufficient. You're delaying the claim. You're not asking for anything specific. You're asking for an EUO to be scheduled at a certain time or a signed statement. And I said, no, look at the first box. It's checked off. We requested photographs. We moved on. And we
Right.
prevailed on that motion, by the way.
You are, I
But
mean, there is case law that these plaintiffs you hear day after day, and they put in their oppositions, and this case law, the appellate terms, and they come back saying that a request for, let's say, a signed statement without more isn't going to be a proper verification request. They treat them as delay letters and ineffective. There is case law out
yeah,
there that says that.
yep, they were citing some today. There was Health Needles Acupuncture
It's a
versus Praetorian Insurance. It's actually in front of me because we just did it today. It's 46 miscellaneous third 132. That's the citation. And it specifically says you failed to request specific verification. They called it a generic delay letter.
right.
Something like that could make us lose. Yes, we could argue that it doesn't matter. There's that Westchester and Canarsie case that says you can't just ignore a verification request. You have a duty to respond.
Right.
Inaction is not a defense. But why do we even need to go there when it's as simple as picking something tangible that is relevant to the claim
Mhm.
and mark it on that verification request? I think that's very important.
Right. And this concept can seem a little confusing, and I could see why this could seem a little confusing. But if we walk this through logically, the provider stands in the shoes of the assigner. And if we're saying to the provider, hey, here's a verification request, we're within our time frame to verify this claim. Your claim is delayed pending the signed statement of this assigner. Really, the argument from the other side is, well, you're not requesting anything specific from me.
Right.
So whether or not I stand in the shoes of the assigner,
Right.
I don't have to provide you with anything because nothing's being requested. So
Right.
sometimes we lose that argument if we're not requesting something specific. So that's why it's our suggestion. We urge the adjusters to think that way. Is let's request something specific. Photos is a great one to put in there because it's relevant on every case, doesn't matter what case it is.
Right.
So that's really our suggestion there.
Yeah. So let's talk about bef let's talk about verification in general, because quite frankly, I mean, I think that's one of the most complex areas in insurance defense in general of these verification procedures. They can get tricky, and especially when it comes to, the type of verification that we're asking for. Um, so the time frames that we go by are the 15 days, 15, is it 15 business days from the date of receipt of the claim?
Correct.
And then they have 30 days after that to
Respond.
respond. If they fail to respond within those 30 days, then we have 10 days after that to
Business.
send the second request. So
Mhm.
what's the
Correct.
difference between business days, calendar days? How's that all work?
It's business days. So you receive the bill, you have 15 business days to send that first verification request, and
Right,
that starts the tolling process. Then they have 30 calendar days to respond to our requests.
right.
Then after the 30 calendar days, we then have 10 more business days to send that follow-up verification request. And that was something else I was faced with today. Just because you send it, let's just say on the 18th business day, it doesn't mean that your denial is untimely. It just negates the days that you then have to ultimately deny the claim at the end. So if you lost 3 days because you sent it 3 days late, that first or second verification request, as long as a denial was sent within 25 days from when that was received, it's still only 28 days and it's within that 30-day time frame.
Right.
That's important. That's really important. And it comes up sometimes, and I've seen defense counsel miss it, quite frankly. Not our office, but I've seen them miss it.
Good.
Never our office. But you have to be aware of these rules because they can get, very specific.
Yeah, yeah, no doubt. All right, let's talk more about the verification requests as far as I mean, the verification rules. I mean, if we're asking for a wholesale invoice for maybe a test result, those are kind of easy to understand that that's verification directly sent to the provider. But when we're talking about signed statements and EUOs tolling a claim, how is that handled with the courts? I know we just talked about it a minute ago, but let's go over that because it's important. Because a lot of times what we do see is a verification request saying the claim is being delayed for signed statements for A, B, and C. And sometimes it'll say the claim is delayed pending investigation of accident details. That type of stuff going to get kicked out pretty much every time,
Mhm.
right?
They're definitely not favorable to the court. I mean, is it a guaranteed kick out? No, but it's definitely not a strong verification request.
It's just
Right.
there's no case law that definitively says everyone has to go this way. So it's open to interpretation, and we try to limit that as much as possible going in there.
Right, but
Right.
if there's a general verification request, those cases Christina cited, plus there are more that we see in their oppositions to our motions all the time. They're going to be putting these forth saying that this is it's a delay letter. I say I'd like to see all of us in this no fault realm as the defense end never use the word delay again. I'd be very
Right.
happy with that. There is
Well,
no
you
Right.
know,
such
it's
thing.
sorry.
Yeah, well,
No, it's funny because our verification requests, they say both. They say, in many that I've seen, it says your claim is delayed, and then it goes
right.
on. We request verification. It actually uses both of the words in
Yeah.
the
Let's
request.
not, I would like to see in a perfect world, we don't use the word delay ever again. We get rid of it in our vocabulary. We use the word verification and the word told, because
Oh,
basically what the verification request does is it tolls the 30-day period. I mean, it puts a stop on it. It shuts it down. It doesn't delay the claim. Delaying the claim is not a good thing. We never want to delay a claim. We want to move things as fast as possible. So if we think about it in terms of verification and tolling, what can be used for that purpose? So if A recommendation would be to SIU and to adjusters, if we're doing signed statements on a claim, you can send if you get a bill in, let's say January 1st, you can send out a verification request saying that there are signed statements pending, putting the date of the signed statement that it's scheduled for is best. Can't be just left open-ended. There needs to be a good reason why, and also ask for the other things that you would require in a signed statement, such as photos. Key. You're asking for photos, you're asking for videos, you're asking for this type of very specific information to verify the accident, not just a general overview. I think that's going to be more effective overall.
It's the airtight. I love that. I
Mm.
love that completed verification request.
Yeah, yeah. And the tolling ends when the verification's received. And we know this, and then our 30-day clock starts to tick, generally speaking. The For EUOs, it's when the EUO is held or when the second no-show occurs, we use that as the date. For signed statements, it's either when they didn't show up for the second or third time when the investigation was concluded, or when they actually do show up for the statement. There was also a question regarding EUOs and requesting signed statements initially and then going into the EUOs and having that entire chain of verification hold up to toll the claim, meaning the bill came out on January 1st, signed statements were requested, a signed statement was taken on February 5th, and then let's say now we need EUOs to go further. How do we feel about those? I mean, it's legitimate verification request. It should properly toll if done correctly, but we don't see it that much. But that's a concern that I think we have as defense counsel watching that chain of events go down. You agree with that?
Again, not a
Ideal.
100% slam dunk. It's not ideal.
Right.
Again, it depends on the judge sitting at the time. It depends on what nuanced kind of arguments plaintiff's counsel is going to make and how we're going to respond to that. Not ideal. I think that's the best way I can say it. We want to make sure that we're following the regulations timeline constraints as close to the way that they're illustrated within the regulations as possible.
Right.
We don't like to, make our rules as we go. Again, not everything is black and white, though. Sometimes we think a signed statement is going to be sufficient, and then we discover there's more that we need, and so we want to schedule the EUO. In a perfect world, we would want the courts to agree with us there, but they don't always do that.
Right. So the takeaway from this is, if we're asking for signed statements, don't be general. Let's not put in that it's just pending investigation. If there are signed statements, we could try to put the dates in that the signed statements are scheduled for, and ask for relevant information to the claim, such as, a good idea is photos or videos or things of that nature.
And I feel that third one is most important. So even if you
Photos.
had general pending for signed statements coupled with photo requests, I think it's still a solid verification request.
Yeah.
I really think the key is asking for something tangible.
Yeah.
Right. And just to build off of what you were saying, Mike, when the claim is deemed verified, whether that's by way of a no-show or by way of them appearing, sometimes on the signed statement end, or when we deny for non-cooperation, that's a little bit more of a gray area. And we want to illustrate as specifically as possible all the attempts that were made by the SIU. Oftentimes it's enough. Sometimes it's not enough. Sometimes arbitrators and judges feel that, going to someone's door and knocking on their door or making a cold call.
They do.
There's no but there's no obligation for somebody to answer that. And then does that arise to the level of non-cooperation? Not necessarily.
Right.
Or sometimes an SIU will then say, hey, we tried 10 times to get in touch with this person. Now we're deciding that this day is the day that the claim is verified and we're going to deny. Sometimes plaintiffs will argue, well, this is such an arbitrary date. How did the SIU decide that? So as long as we have enough under our belt or enough attempts to illustrate that this
Right.
person really failed to cooperate, especially when they have an attorney and the attorney CC'd on those letters.
Yeah.
The attorney can't get their client to communicate and show up. We have a better chance. But again, not really black and white on that issue. The courts are not, the arbitration is not. And so we want to be showing them a full picture of many attempts as possible. Really, due diligence is the key there.
Yep.
I do think that they do follow, and they seem to follow how IMEs are scheduled when it comes to signed statements, EUOs. I feel like that's that controlling subject, where they say, okay, well, if it's rescheduled, then it's a reschedule. You'd have to reschedule it. So it's not considered a no-show. You know how the IME
Right.
no-shows do it that way? I think that's how the courts follow it with EUOs and signed statements.
Yeah. Yes,
Yeah.
they do. Yeah.
Right. They don't want it to be adversarial. And really, the premise of no fault, right, if we go back all the way to the beginning of this, is that they want open lines of communication. So oftentimes, we'll even hang our hat on that argument, is especially when they're not complying or they're not responding to letters that we're sending out. Really, that's the whole premise of no fault, is to keep this continual open line of communication between the parties.
Yep. And look, we need for all of this stuff, we need timely denials, except for fraud. 30 days, even with an EUO, we can have a rock solid no-show. And if the denial's late, it throws us, we're done. They are waivable defenses. So it's really critical, the timing factors involved. And I was asked a question a long time ago by an insurance carrier, and they asked the question, where does this all go wrong? Like, where is the risk and exposure? And the answer to that is really in these time frames, because we can do everything right on our end. Whoever's processing the claim, everybody gets everybody can do everything right, but then, something gets lost in the shuffle and there's a late denial and we're kind of out of the box on it. So that's really an important step in this process.
Agree.
Yeah.
Well, it's on a technicality, like a time frame or an
Yeah.
untimely.
Yep. So what I'd like to talk about for a minute is, let's assume that we go through the signed statements, nobody shows, or they show up, and then when they escalate it to an EUO, they're allowed to ask for that additional verification. Well, we're dealing with fraud defenses, stage accidents, fraudulent events, as we know, so those denials don't have to be timely. And as long as our proof in admissible form, as we discussed earlier, with transcripts and things of that nature are in order, the denials don't necessarily need to be in the 30 days. Mike, I guess my follow-up question before we conclude on this well, let me ask you guys, do you have anything you want to add at this point? I mean, I know we covered a lot of stuff as far as the verification goes in the process. You see, I like talking about EUOs, but verification with stuff, not so much. Makes me crazy.
No, I mean, I would love we deny something on like fraud or misrep. I mean, the best case scenario is something like, did you receive a neck collar? And they say no, and the provider builds for it, right? Those are clear and cut. But when we have like a whole bunch of like 3 different parties giving statements about how the incident occurred, and one person got picked up first and the second part, that is not enough to establish a fraud and misrep. And that's definitely something that gets raised all the time by plaintiffs, and they're right. It can't just, you're right. It has to be clear and convincing.
Well, I mean, the level of proof that's required for a fraud.
Yes.
What you're referring to.
Absolutely.
Yes, of course.
I think the way, I guess my last piece that I would close with is on this issue is for us going into this stage of the claims verification, for us going into now conducting our investigation, what I like to do, and I'm sure Mike and Christina, you guys would agree, is that I like to think as an adjuster or an SIU would. What do they want? What are they looking for? What do they need from us at this stage? And what my piece of advice is that when all of you adjusters and you SIU personnel are handling the claims a little bit earlier than when we get our hands on it, I'd advise that you all think like lawyers. And so what is the plaintiff, what is the applicant going to argue against? Am I adhering to these timelines? Did I send out the letters in a timely fashion? And I always say, and I harken back to this, but if you're thinking like a lawyer and you're anticipating the arguments of the other side at that point of the claims verification process, and you're not sure about something, you can always call us. I think that's
Yeah, of
very
course.
helpful. You know, we make ourselves available all the time. And so if there's any kind of question or confusion, even just, you know, in terms of, am I sending this letter out in a timely fashion, or does this
Right.
denial sound okay?
Right.
I think that's important. You know, we should be involved with each other from start to finish on these cases.
Yeah, no doubt. So
Absolutely.
in a nutshell, I mean, basic verification, 15 business days, then without no receipt in 30 days, must follow up within the 10 days. For signed statements to the EUO, we want a logical progression. It can't be looked at as like a delay or a stall. Adjournments, things of this nature must be considered. And the 30-day clock starts when the verification is complete. Unless a verification is like 1 or 2 days late, there is case law that says that we can now, instead of having 30 days to deny, we have 28 or 27 days to deny.
Yep, that's it in a nutshell.
That's it in a nutshell. On
It's not as
the
easy as it sounds.
right, and on the signed statements, let's when we send the verification requests out, get rid of the word delay. Put in the date of the signed statement if you want, if we know what the date is, and also ask for other verification information that you know that you need and that's legitimate to ask for, such as photos.
Hmm. I mean, you do
And
want to notify them that there is a toll. So I would also, and you mentioned it before, add your claim is tolled. That's really the key
right,
word. That,
tolling,
yeah,
correct.
yeah.
And I know we went over it, but to sum up again, when this was a very specific question, when a claimant's attorney says my client is not appearing for a signed statement, my client will only appear for an EUO. That's the only thing he's required to do. Now, remember, the signed statement is not part of the no fault reg. It's not part of the mandatory endorsement. It's part of the cooperation clause. Technically, to show a failure to cooperate, it's like a wanton disregard. It can't be just, we tried, if the attorney is cooperating, saying, I would rather do an EUO on the record, that's going to be considered cooperation. They're going to get away with that. So
Hmm.
if they say my client won't appear for a signed statement, only an EUO, and we want to proceed, let's do the EUO and not deny them for non-cooperation at that point because they weren't not cooperating, basically. Agreed on
I
that?
agree with that. I agree with that. Although I have seen it go our way.
Yes, but
Yes.
again, I really just feel like it's judges who aren't well versed in the no fault law, and eventually it'll no longer go our way.
Right. Yeah. You know, I would advise the same thing that Mike is advising, as to why leave that open to the possibility of losing that. But I have seen judges and arbitrators let us know that it's not up to the attorney to determine how they're going to cooperate or how the carrier has to conduct its investigation. You know, that's my argument all the time is, well, it's not up to
Well,
them
let's
how
say the
we're going to conduct
scenario
our investigation.
occurs. Let's say the scenario occurs, which we've seen where the attorney says my client's not showing up for a signed statement, only an EUO, and the SIU reps as well. We need to discuss this with your client, and they refuse. And if they're asking for other things, like do you have any photos? Do you have any of this? And they ask for verification, and the attorney just refuses. It's a fine line on whether or not at that point they can
Hmm.
deny the claim for non-cooperation, and it will be under the non-cooperation clause. The thing with the no fault is that at the stage of the litigation in the no fault, that's usually it's now down the road a bit. It could be a year, it could be up to 6 years, right? And now we're defending this claim, and we're going to have our scheduling letters for the cooperation and the SIU affidavit saying we tried to schedule, they refused. So a lot of times the attorney who you were dealing with on the EUO and the signed statement and the claimant themselves are no longer relevant. They're not there. It's going to be a paper trail. So that's why we have to be really careful on our paper trail and what that actually looks like down the road. Agreed on that.
Yes,
Oh,
absolutely.
yeah, absolutely.
It's like when we do an EUO, right? When we do an EUO, we keep in mind that we're creating a story to be read. You know, it's a transcript. Silences or dramatic pauses or smirky smiles aren't recorded. So, you know, that's why, like, I think Christina, you did that. Let the record reflect that the
Mm,
claimant is, XYZ
yeah,
right now, doing whatever he's doing. His head just at the table.
right.
But you
Right.
do say it out loud so that gets picked up.
Yeah.
Yes, and the person says they can't sit longer than an hour and it's been 2 hours.
Right. Yeah.
Let the record reflect we did not take any breaks and the person is 2
I
hours.
can't lift my right arm. Which one? This one.
Now we're just being nerdy lawyers, but yes,
Yeah. All right. All right. Enough of that banter. So I think we covered what our goal here today was to cover. There's obviously a lot more that goes into each of these sections that we can go into. If you have questions, or if you want us to dive deeper into any section, or if you disagree with anything that we said, because that's obviously quite possible, please just let us know, and we'll be sure and more than happy to follow up and go into more detail.
Yeah, I love that little
On that
close.
note, ladies, I bid you adieu. Have a wonderful evening. Thank you
Take
for your
care.
time, and I love this training. I love EUOs.
So do
Yes.
I.
Talk to you guys later.
Bye.
Bye.